Thank you, Peter. Can everyone hear me? Okay, great. I think I have some sense for the composition of the room and who's here, but can I just see a show of hands how many of you are students? Okay, great. And how about faculty? Okay, great. And lawyers, mediators? Okay, great, wonderful. Happy to have you. Okay, so today we're going to talk about something that's pretty simple, but something that I think is probably going to come up at some point in your careers in the future, or perhaps even right now if you're a business owner or an entrepreneur. And that is 10 things that you need to know in order to protect your company and your brand names, okay? And so just to give you a little bit of perspective, when I graduated from the best law school in the whole nation, Richardson School of Law, I was prepared to be a lawyer, but I really didn't know a lot of practical things, including what intellectual property is. And now that I'm a general counsel of an IP firm, I know more than I ever really thought I needed to know or wanted to know. But I didn't, when I first started, I didn't even know the difference between a patent and a trademark. How many of you will confess that you don't either? Okay, that's okay, because today our goal is to share with you some information about intellectual property, and in particular trademarks, copyrights, domain names, rights of publicity, all kinds of things that you probably never heard of, but for sure you have some connection to these concepts. And now you're going to be able to talk freely at cocktail parties because you're going to know a little bit about a lot of things after today. Okay, so what we will accomplish today is, let's see, which button? Is this working? Right button? Not working. Okay. Oops. We probably should have tested this beforehand. But, okay, so whether you work for a company or have your own business or you plan to start a new business in the future, protecting your company name and your brand names is critical. And so we're going to cover, as I said, the top 10 things that you need to know. Okay, so here they are in order in which we're going to cover them. Okay, so the first thing you need to know is, how do I choose a trademark? And we're going to talk about what a trademark is. So how do you select one? And kind of very closely related to that is, once I choose a trademark, how do I make sure that I can use that trademark? In other words, are you sure that someone else isn't already using that trademark, which is a very important thing to consider. And then once you have a trademark that you think, yes, I'm going to go forward with it, I'm going to use this as my company name, or I'm going to use this as my brand, or I'm going to use this as a product name, it's important to register the trademark, and we're going to explain why that is. And then once you have a registration, or if you don't register your trademark but you still are using your trademark, how do you make sure that you keep it in force and keep it active and valid and effective? And if you don't take certain steps, then you actually might put your trademark in jeopardy, and you surely don't want to do that. We're also going to talk about how you protect your trademark from being used by others who shouldn't be using it, so without permission. And unfortunately, that happens more often than you would think. And in fact, Jeff gets calls all the time from his clients saying, gosh darn it, I see that someone in the same business as me is using this particular trademark, and what can I do? What should I do about it? Well, we're going to talk about how you can actually stop someone from using your trademark, which is no small task. It can be expensive. Sometimes it can be very inexpensive because the person's doing it innocently. Or sometimes they, once Jeff Van Hoosear writes to them, they will say, okay, I give up. I won't use it any longer. So this symbol is a symbol that we use in the United States and internationally too?
Recognized.
Okay, recognized internationally. When you have registered your trademark with the U.S. government, you're entitled to use that circle or symbol, which tells the world that you own that trademark or you've registered it with the United States Trademark Office with respect to a certain class of goods. And Jeff can go over that later in the presentation, but this is a really good symbol to use once you have that piece of paper that says you're registered. Okay, what else do you need to know? You need to know what copyrights are, copyright rights. And we're going to go over that because undoubtedly you will use, in connection with your business, with your companies, things that have copyright associated with them, and you need to make sure that you protect those as well. And then, kind of in the same vein, virtually all of you have are associated with or you know of domain names, website addresses that you also need to protect if you have a business or are with a company. And then there's something called a right of publicity, which is associated with famous people. So if you want to, we'll go into it, but for example, if you want to have or include somebody's name in a marketing campaign or a famous person's photo that might be wearing one of your products, that person has a right of publicity, and that's something that you need to make sure that you don't impinge or infringe upon. And then finally, we're going to talk about privacy rights, which is really something that is trending right now. There's all kinds of new privacy laws in Europe, in California, and some other jurisdictions that you need to know about if you're doing business in Europe or with California consumers. So we're going to talk very briefly about those kinds of rights. Okay. So, and this is very informal, so if at any time you have a question, please feel free to just shout it out. And then we'll stay for a little bit after the presentation if you have a question that you'd like to ask. So let's talk about intellectual property. Intellectual property is a very broad term for a number of different property rights. And this is what our firm does. This is all we do. So what we're going to talk about today are the first two, maybe a little bit about the third. But we're going to talk about trademarks. And what trademarks are is a trademark will identify the maker. They call it the source of goods, but it's really who makes these goods, who manufactures them. That's what a trademark will tell you. But a trademark also reflects the goodwill, and I think some of you have heard that term, but basically goodwill in the trademark sense means the reputation that company has with consumers, that it's recognizable by consumers, and so it has a value associated with that logo or the name. And then we have copyrights, which are different but can be somewhat related to trademarks. So copyrights are an artistic expression. So if you think about artists, so artists who have, who paint, artists who sculpt, artists who sing, recording artists, musicians, graphic artists.
Fabric prints.
People who make garments out of vintage kimono fabrics. I have a friend here who does that. So these are all things that are possibly or definitely copyrightable, which means you can register with the federal government and basically tell the world that you are the artist. You are the one who have expressed your art in some fashion, whether it's with a song, composing a song, or something that you can see or hear. Okay, then we have trade secrets, which are also property rights, but trade secrets, we didn't write this word, but it's really about confidential information. We call it proprietary data, but it's sort of, it's really that, a trade secret. It's something that is not known to the public, that you keep confidential, and it's, for example, the recipe for Coca-Cola. Okay, that is a trade secret. Of course, they haven't filed anything with any federal government agency to let anyone know what it is. They would prefer to keep that as a trade secret. And so recipes are a good example of a trade secret. But it could also be a software program could be a trade secret. Some people, if you can reverse engineer it, probably not a trade secret, right? So, and it has to have commercial value in order for it to be a trade secret.
Customer lists, vendor lists.
Right. Okay. Patents, on the other hand, cover innovation. So something that you invent. It's not ever really artistic. It's something, and it can't be sort of, something. Well, it can be useful. Trademarks can't be useful, but sometimes you can actually take something and protect it under two different laws, and Jeff will get into that. But patents generally have to cover technology that is new, that's innovative, and that nobody else has invented before. Okay, if somebody has invented it before, then that is prior art, and you're not going to be able to get a patent. And that's what the U.S. Patent and Trademark Office. And then there are also comparable patent offices around the world where you can try to obtain a patent in order to protect your technology if you sell products in that country. And then finally we have what I talked about earlier is rights of publicity and privacy, and that is basically the right of someone to control the commercial use of their name. So Jeff Van Hoosear, their image, a photo of Jeff, or a likeness, a caricature of Jeff. Now, I think he's very famous, but he's probably not famous to a lot of people, so I'm not sure what his rights of publicity would be, but someone like Taylor Swift obviously has rights of publicity, and she also has rights of privacy, as do all of us as consumers. So we're going to talk about that. Okay, so we talked a little bit about branding, and a lot of people are confused. Wait a minute, what are you talking about? What do you mean by brand? What do you mean by trademark? And they're sort of similar, but also distinct. So your brand is your image and your reputation that you've developed in connection with your business. So, do you produce high-end luxury goods, or are you providing, less expensive goods of good quality, but at a good price point? So that's your image and your reputation. It's what the public sees and thinks when they hear your name or read your name or see your logo. Trademarks, on the other hand, are the aspects of your brand, so it's sort of like a subset, that are unique and special, basically what you can protect. So if you look at these two emblems and the words, so Toyota and the Toyota emblem are trademarks, and so is the word Porsche and this Porsche logo. But in terms of branding, two totally separate things, right? When you think of Toyota, you think of good value, well-made car, will last a long time, good fuel economy. And then with Porsche, you think of, high-end luxury, expensive, just really, really a luxury vehicle. So that would be the branding, and then the actual words and the logos would be the trademark. Okay, so here's some very famous, and maybe not less famous, trademarks that you probably are well familiar with. The best university in the whole world, University of Hawaii. I personally think the best fast food place, Zippy's, which I always go to right after I land at the airport. Queens Medical Center, which our firm is also very privileged to represent in protecting their technology. Hawaiian Airlines, we don't represent them yet, but we'd like to. Big Island Candies, really tasty treats. TNC Surf, Dole, L&L, right? Very, very recognizable trademarks in use here in Hawaii and throughout the United States for some of them. But right off the top, when you see this, you know what they sell, right? And you know their reputation for, good plate lunch and restaurants for late night or whatever, great medical center. So this is what we're talking about when we talk about trademarks and goodwill. Okay, here's some others. Kate Spade, Chef Zone. You might see the huge red warehouse over by the airport. That's related to Waihata, which is a big distributor. We also represent Amazon.com. Kodak is very recognizable, and of course IBM. So that was word marks. These are symbols, designs, or logos. We also represent Monster Energy. And by the way, if you ever think about using the word monster and this kind of symbol, scary looking, don't do it, because they're very, very aggressive in going after anybody, even monster trucks that try to use this kind of emblem. They're very, very aggressive about protecting their logo. How many of you recognize this symbol? Who knows what that is? Right, HIC, Hawaiian Island Creations, of course NBC, Louis Vuitton, Nike, we've represented, Starbucks we represent. Interestingly, we represent Starbucks with respect to patents. So like their mobile ordering systems, we've obtained patents for them on that. And then of course Apple. So here's some examples of some non-traditional trademarks. Believe it or not, MGM has a trademark on the lion roar. And Pillsbury has a trademark on the Pillsbury Doughboy giggle, I guess.
Giggle.
So you can actually trademark sounds. I think, isn't Harley Davidson, don't they? Oh, okay.
Tried.
They tried to register their very loud, obnoxious, sorry. I find it obnoxious, their engine sound, and they weren't able to. Then, of course, you have slogans. Don't leave home without it, or just do it. Or you might have a slogan that you use for a restaurant, and that would be what we call a service mark, which is protectable like a trademark. And then, believe it or not, you can actually try to register a mark for a color that's associated with your goods. So, for example, Owens Corning was successful in registering the pink color for their insulation products for their homes. And I noticed locally, how many of you know the company that has storage facilities in the islands that are orange, with orange doors? Okay, who can tell me what the name of that company? Right, Cedric got it. Public Storage, which we're also very honored to represent, but they are very aggressive in protecting the color orange associated with their line of business for their facilities. So,
You forgot the famous jewelry company that has a color.
oh yes, there is a famous jewelry company that has a color associated, almost like this color of this chair. Who knows what that is? Tiffany's, right, of course. So see, you've already identified the source associated with that mark, that color. And that's what these very famous companies attempt to do. So can you do that? Sure, why not? You can have a dream that someday, if you get to this point where you can register your color with your company, you've made it. All right, and you can also actually register a trademark for a shape of a product. Who can identify what that is, what company that is? Very good, Weber Grill. So that actually is registered. So the point of all this is that it's not just the name of the company, it's not just a symbol, but it can be sound, slogans, colors, and configurations. Okay, so how do you choose a trademark? I would suggest that you try to make up a name. That is the absolute strongest way to protect a trademark. So the word Haagen-Dazs, or the name Haagen-Dazs, is actually totally made up. But that's a very strong mark because when they chose that mark, nobody else was using that name. So that is a very, very good trademark, and courts will enforce it against people who try to copy it. You go from that down to here, which is a generic term. Escalator has become a generic term. Kleenex would probably be another one. That's why Kleenex, well, they think, that's why you don't want to call it Kleenex. They always call it Kleenex tissues, right? Because if they just called it Kleenex, then all of a sudden it would become like escalator. I didn't even know that escalator used to be a mark. Okay, but, okay, so next strongest next to a made-up name would be something that's a little bit arbitrary, just a real word, but Amazon, like how or why did they pick that name? Do you
Large,
know?
big.
Oh, big. Okay, so that's okay, and they are. Microsoft was suggestive of software. American Airlines. Okay, so under this category, descriptive, it's not a real great mark if you can tell what the product is by what their name is. Now that kind of sounds counterintuitive, but if you have, what would be a good example? Like,
Of descriptive?
yeah, something.
So descriptive is not only descriptive, it's geographical or a surname. Surnames fall under descriptive category well. Laudatory marks, thrifty falls under descriptive.
Because or like 99-cent store. We
Best
represent.
Buy would be descriptive in connection with it being laudatory.
Yeah, not the strongest mark because it describes what they sell or what they make.
But over time, over usage and over advertising expenditures, it can become well known. Obviously, American Airlines, is now a strong trademark just because of over time and its use and its recognition.
Right. One of our friends who owns a company, he's also on the PACE board. His name's Tom Nichols. He created this medical device cosmetics company called Pratika. He was trying to go for pretty, and then Ika, I'm not sure what that is, but Pratika. And he thought he had it made, but then all of a sudden he found out that Pratika is a name it's an Indian name used in India for girls. But did that ruin it for him? Not really. Because it's okay to choose a name, but it didn't really describe what he was making, so it's pretty darn good mark. Okay, so that's how you go about choosing a trademark. And from here, I'm going to turn it over to Jeff, and then I'm going to kind of be a color coordinator and talk about or ask him some questions that maybe came up in my career. But Jeff, go ahead.
So as Wendy said, please feel free to ask questions. Make this interactive if you like. If you have anything that I'm covering that you would like some more information on, please by all means just and we'll do our best to answer those in connection with it. So how do I make sure I can use a mark? So some of the things you can do yourself very easily, thanks to technology, is do your own searching. So you can go to uspto.gov, which is the U.S. Trademark Office, and you can do some searching on there. It's not terribly user-friendly, but it is available to use, and you can put in your mark, and you can even do there's some tutorials on it that will help you know how to do some searching in connection with it. So you can look up to see if your mark or your proposed mark is already filed for or registered at the U.S. Trademark Office. That's a very helpful screening tool to do, kind of right away. The other thing we recommend doing is doing some searching on the internet. Common law trademarks are available in the United States, so if you just use a mark, you've got some rights. And so if you go and you type in your proposed mark into Google and 5 pages of things come up referencing another company that's using that term, then that's a sign that there may be some trademark rights, common law trademark rights to that entity that you'll have to pay attention to. The other thing is the domain name itself. Most businesses are e-commerce oriented or a connection with some type of internet advertising or marketing. So if someone already has the domain name registered that you would like, that maybe make it a little more difficult to get trademark rights or service mark rights. And so you'll see we'll talk a little bit more about that. You can always hire someone to do a search. There's search firms and law firms all do this. We do a lot of, every day I probably do 4 or 5 in-house screening searches where we do a combination of these things for clients and give them kind of either red light, green light, kind of quick review of a mark. A full search is a kind of a legal term we use internally where we will go through an outside service. There are many of them that not only will search the records of the U.S. Trademark Office. Every state in the United States and territories like Puerto Rico and Guam also have state registration systems, so you need to look at those databases in particular, particularly for your local service business. Those may be of concern to you. And then a full search will look at Dun & Bradstreet records, business journal records, a lot of other name records to see what else common law might be out there that show up. And then international searching. Trademark rights, for the most part, are all territorial. So if you want to expand your business outside of the U.S. to Canada, Mexico, Japan, Australia, you might need to do some searching there. Yeah.
What is an average price to hire someone like a firm like yours to do a full, maybe say, international search?
So generally what we do in connection with clients is there's kind of like stages. You'll do what we call a screening search or a knockout search at the beginning. We'll kind of give them a yes or no, because a lot of companies will come to us and say, here's the mark we've been using. So you approach that a little differently than if they say this is the mark we'd like to use, of how you go forward with it. But a lot of businesses will come to us and say, here's our top 3, here's our top 5 choices that we've kind of vetted internally to like. And so we'll do a screening search on those, and that'll range like a couple $100, per mark in connection with doing that screening search. And then maybe you knock out 1, 2, 3, hopefully not all, 4 or 5 or whatever you're doing in that, and then you'll go on to the next level. And you'll go on to a full search level, which costs you about $1,000 in connection with the legal services and the outside services. International services can be expensive. Law firms typically have databases, because most databases of foreign countries are available for a fee, and so we have all these databases that we subscribe to. So we typically can do an internal screening search. It's very difficult to do the same type of full search on the international level, because you really would have to go country by country. So you're looking at literally $1,200 to $1,500 per country to do the equivalent of a full search internationally. Just cost prohibitive for almost every company to do. But you can do some international screening searches for about $400 to $500 and get kind of a feel of the lay of the land in that regard. So it's not a terribly expensive process, particularly when you're comparing it to the patent rights that you may have to do and the expenses associated with those.
But this is something that you should do if you're launching a product. You should think about the product name if you're going to use a product name very early in the process, because when I was at my last company and I was general counsel for that company, I can't tell you how many times I got a call from our marketing department telling me that they're going to Vegas to a trade show next week and they're going to launch this trans flush product. And I'm like, what? We didn't search that. What do you mean? So then we started doing the searching, and we discovered, and we're a national company, we discovered a transmission flush shop called Trans Flush in Illinois. So then we had to knock that name out, because they could say we're using their mark, So we went through probably 5 names for different possibilities for transmission flush equipment. And you know what name we ended up with? The Wynn Oil Company transmission flush machine, because we just couldn't find the right mark in time. And you can save money by doing that, by just not having a trademark, but of course it's not great from a marketing perspective usually.
I think I covered this later, but if your company is going to be doing any e-commerce or really depending largely on the internet for marketing or advertising, the domain name search right away is critical, and to register those names at those times. It's very hard to find a short domain that's agreeable with whatever your trademark or service mark might be. You can register it for a year, anywhere as low as like $10, $15, $20 on different registers, whereas if you wait, it's first come, first serve on domains. And so like if you wait, we've had many clients say, oh, I didn't do it yet then because we had 3 that we were looking at. I'm like, okay, now all 3 are unavailable, from a domain perspective. So just do that a year, inexpensive, gives you that security protection in connection with it. The other thing that Wendy mentioned on these is these in-house screening searches, and particularly a full search. You can do them very fast. You can do them in 12 hours, but you're going to pay for it. Whereas if you get the normal turnaround time, which is 4 or 5 business days, it's much less expensive. So those costs I just gave you really are like the normal turnaround time, where you need it with you may need it within a week or 2, but if you need it before the next day's show, you're gonna wind up paying premium prices to get all that stuff done in time. And so just some planning ahead will also save you a lot of money. How do I register a mark? So the main thing we would encourage most businesses to look at doing is a federal registration that covers all of the United States. I'm going to back up a little bit here. Copyright rights and patent rights are only federal law. Those are based on rights that are given in the Constitution, so they're federal rights. There is a federal trademark registration that's a statute, so it's at a little lower level than the patents and copyrights being in the Constitution, but every state has trademark laws as well as all the territories of the United States. But a federal registration would cover you nationwide. So there's federal law to look at for trademarks as well as state law. And then state rights of publicity and state rights of privacy are state law rights. Trade secrets are primarily state law rights as well, although a couple years ago there was a federal Trade Secret Act passed, so now there's a federal statute, like a federal statute for trademark registration. But we would usually encourage federal registration. Now you may have a very local service mark business, and so it may make sense on some point to do a state, and I think we talk about that a little bit later. But the federal registration gives you prima facie evidence of ownership and validity, which is very important in an enforcement procedure. Incontestable status after 5 years. What that means is that after 5 years of your registration, no one can come to you and say, oh, but I was using this mark prior to you, so you have to stop. After 5 years of a registration, your rights are set. So that's a very important right to get and to be able to not stop anyone. And that's because of the common law use in the United States. You could be here in Hawaii, there could be someone in New York, you would never ever kind of cross paths. Definitely pre-internet you wouldn't have crossed paths. But after 5 years, they can't come back and tell you to stop. For a lot of companies, a lot of my apparel companies, handbags, shoes, so forth, registering their marks with the U.S. Customs is very important to keep out knockoffs and counterfeits and other lookalikes and things with that. The federal registration of trademark allows you to do that. So a very important right that comes along with federal registrations. The other important thing is kind of in looking ahead is you can file a federal application to register based on an intent to use, but at some point the U.S. law requires that you commercially use the mark in order to get the registration. So like the domain names, check and file your applications kind of early on in your business, but eventually you're going to have to follow through and use them in connection with it. Now certain industries get kind of a little bit of advantage. Pharmaceutical and medical device industries, clinical trials, clinical testing counts as commercial use, counts as use in connection with that. Software companies and hardware companies that do beta testing and things before they actually launch a product on the market, those uses count, so those are good. Even my consumer clients in connection with cosmetics or food products, certain types of testing will count as commercial use, and so get you to be able to file the use and obtain the registration in connection with that. State registrations, you can do a state registration in every state, must be on actual use. In every state you must have actual use before you can file. Sometimes you can't get a federal registration. Sometimes your mark is considered descriptive and you won't get it, but you can go on the state level if you're in use of it. They're inexpensive and they're quick. Hawaii's is $25, and you can do an expedited fee if you want, so very inexpensive in connection with that. To give you the range on the federal fee is $325 per class. The class system is a little confusing, but every single good and service is put into one of 45 classes, either logically or sometimes illogically in connection with it, but everything has to be placed, and so you pay the U.S. government and the state governments by classes. So if you're doing apparel, you've got class 25, $325. If you want to add in handbags, class 18, another $325. You want to add in sunglasses and eyewear, class 9, another $325. So it can add up in connection with that, but the states usually are pretty quick and inexpensive. Quick meaning 2 to 4 weeks, whereas the federal registration, your best case is about 10 to 12 months. So again, in your planning stage.
When you file an application for a mark, are you guaranteed to get it?
Absolutely not.
Okay, so
even if you've done your searching.
What happens
even
after
if you've
file?
done your searching. So after you file both on the state and the federal level, they will do a search. They will search the records. The U.S. Trademark Office will search the U.S. trademark records. California or Hawaii, respectively, will search just the state records in connection with it. So we can do searches, and we may say it looks good. I mean, we're never going to give you a guarantee, but when we say it looks really good or 70% chance or something, sometimes we say, hey, there's a lot of other marks on the register. We're giving you less than 20% chance of registering it. Sometimes we're wrong and you get it. Other times, most of the time in that instance, we're right and you get denied because there's something else already on there.
So if your name is McDonald and you want to open a hamburger shop called McDonald's.
If your name is McDonald's, don't even think about a food or beverage or hospitality related service at all. You might be able to get a transmission fluid or something, but you're not getting anything that's edible in any sense of that term even these days. Yes?
If you register in a state, are you only protected in that state then?
That will
At the federal level, you're protected?
Yes. So good question. The question was if you register in the state, are you just protected in that state? That differs a little bit by state law. Most states, the answer is yes. California is a very large state, and California doesn't really give the presumption that if your business is in Southern California, that you're necessarily protected up in Northern California or San Francisco. But for most states, if you're registered in the state, you've got statewide protection. On the federal level, if you have a federal registration, you're protected in all of the U.S. states and territories in connection with that. So that's again why we do the federal recommendation, just for the extent of that protection.
So what kind of additional protection is that state registration compared to just like filing your name when you create your business? What kind of protection do you get?
Yeah, good question. A lot of people say, oh, my trademark is registered because I went to the Secretary of State's office, or I went down to the county clerk's office and I filed my DBA or my business name, my business. That is a type of registration that your business needs and to comply with lots of other laws, business-related laws and consumer protection laws and other things, but it's different. And so the state registration, the frustrating thing for California, I don't have as much experience with Hawaii, but the California Secretary of State's office, you register your trademark with them and you incorporate with them. They don't cross-check those records within the same state. So you can file in California to incorporate a business name, and they'll say, oh yeah, it's available, you can get it, but they won't look to see whether they've already given a trademark or service mark registration to someone and vice versa. So that's a little frustrating in that regard, but that's just the way it kind of is. But if you, and most states, some states are really good, like Arizona is really good. Arizona cross-checks like what trademarks it's given out and what business names it's incorporated in connection with that. Now, fictitious business names, DBAs, and things that are done at the county level, completely different story, obviously. They're not tied with the Secretary of State's office of the state level. And so and that's like what a full search typically does. They look at all those other records to see kind of what's out there, so you know what issues there may be that you may have to encounter with that.
So could these students, entrepreneurs, could they just use LegalZoom and get a trademark? Does that work?
Yeah, so LegalZoom for some cases is a perfectly acceptable way to do it. It's inexpensive legal services. They do a very narrow niche thing of what they have. If you know what you want and you've done your work, your homework, because they're not helping you at all. They're not giving you any really consultation or advice. They're just a conduit in connection with doing it. So for certain circumstances, that makes sense. We deal with a lot of things where LegalZoom didn't work out so well, with that particular client. And it was probably not the path they should have taken, but for some it does work out. So if you, and it's particularly for entrepreneurial people who want to do their homework and want to look into it and understand it, it may work very well, because that's when most people have either time or money. So you got to decide what you're gonna, what you've got that you're gonna do. You had a question.
I was just wondering if it's not a one-time fee when you register your trademark, correct? It's every accompanying?
We'll go through that, but good question. So when you file your application, you're paying the fee in connection with that. On the federal level, between the 5th and 6th year, there's a maintenance declaration that's currently required that is a fee-based, again, based on the number of classes that you use. And then at the 10-year, there's also a renewal application that's due, again, based on fees of the number of classes you do. On the state, you don't have that. You just typically have a 10-year renewal period. So it's just a fee due every 10 years in connection with that. And keep in mind that neither the federal government nor the state governments are going to remind you of those dates. You are responsible for those renewal dates and keeping those docketed, as we would say.
Going back to domain names, if I had the option to buy .com and .org, .net, .info and protect it across the board, is that something you would recommend, or just buy .com?
We would usually recommend that, and that's to keep out copycats and lookalikes and others that may come along that do that maybe redirect those sites, because depending on, as you know, search engine algorithms change all the time as to what you put in. Obviously, when we first started using the internet, we would type in Amazon.com, or Apple.com. We'd put those actually in there, kind of thing. No one obviously puts in, very rarely, I suppose, the .com or the .net or .org, unless you know specifically you need to look for something that has that in connection with there. So we usually recommend, we don't recommend you go crazy in connection with all of them, because now there's 2,000, different, domain names possible, whereas it used to only be 3 and then 4 and then 5, and now there's, literally thousands of it, not even counting all the foreign country level domains out there. But we do recommend that you do look at definitely .com, .net, and .org. Those, as you may know or not know, they were originally set up that .com was commercial, .org was supposed to be for organizational use and network. That all went out the window really, really quickly because there just wasn't enough .coms available, and people fell back to the other ones. So, and if your domain ends in .org or .net, it's not the end of the world if you didn't get the .com, if you're still showing up on the search engines and using that. Okay, how do I keep my trademark in force? So trademark rights, as long as you're using them in the US, you keep them going. They can become generic, and so a lot of brands are worried about that. So you will see Kleenex and Jack Daniels and Xerox, they will advertise about how they are a brand, and they will say Kleenex brand facial tissues, and they will say, Jack Daniels brand whiskey, and they will, do that to try to prevent. This is an old Xerox ad that they used to run about all the marks that had been trademarks at one point that lost. Trampoline and dry ice and high octane and kerosene and escalators in there somewhere in that regard. So as long as you continue to use a mark, you still have rights to it. How do I protect my mark? Okay, use the internet. I mean, the best way you can do is, I mean, there's different services, search engines, Google Alert. For consumer products, eBay and Amazon each have registry programs that will help alert you to counterfeits and lookalikes and knockoffs. We also recommend watching services. These are typically done through the same kind of third-party services that do full searches. Well, they will alert you if an application has been filed for the mark you're watching or if a mark has been published in connection with that. And then just monitor. I mean, a lot of my clients, the way they know about infringements is because they've been alerted by their clients or their customers. They get contents or posting on their Facebook or Instagram page, say, hey, go look at this guy. He's like ripping you off, you know, like that kind of stuff. So that's a very, very common way of finding out the unauthorized use in connection with that. How do you stop? It's your duty as a trademark owner under US law to police and enforce your mark. And if you don't do that, you can lose your trademark rights. So you do have some obligation to do that, and you may have heard the term cease and desist, letters that are sent. We send those every day to different people who are using marks, sometimes innocently, as Wendy mentioned, sometimes not so innocently in connection with that. We also work with, before the Trademark Office, U.S. Patent and Trademark Office, the Trademark Trial and Appeal Board, where we will oppose an application that's been filed, or we will seek cancellation because it's too similar. And then there's civil court actions. Equitable relief is the most usually what you're going to get in trademark cases, unless it's a counterfeit case. You're just going to get an injunction. You're going to get them to stop. It's really hard to get monetary damages in a trademark case if it's not a counterfeit, because you have to prove that but for you would have made that sale. And for most markets, that's really very difficult to kind of do. Attorney's fees are available in trademark cases only for either exceptional, which is a very high standard, or willfulness. And willfulness, again, is counterfeiting situations in that regard. Question?
Curious, China. I mean, do you find yourselves over there a lot? I hear there's all kinds of companies.
You know, it's getting better and better. I mean, we're on this like slope of getting better and better. And China has, because of other trade issues, agreed to do lots of different things in order to protect their rights. But it's been terrible, really. I mean, it's been the trademark squatters that register their marks in China. U.S. Customs prevents things from coming in when you have a trademark registration. The Chinese Trademark Office prevents things from going out through their customs office. And so if your trademark is registered by someone else, but you're manufacturing and you want to export out of China, you will be sometimes barred from doing that because someone else will own your trademark. So it's a very different, process, getting better and better and better. And the reason it's getting better and better is because China now has its own intellectual property rights, and so to protect its own, it had to change its laws, and we're the benefactor of the fact that China is trying to protect its own trademark laws, and so it had to go along with protecting everyone else's in connection with doing that. So it's gotten better and better. Copyright rights. Many of you may recognize this guy and this poster. So this was a very famous copyright case where it turns out this artist, Shepard Fairey, had seen this photo, taken this photo, and then made this rendition of it. And AP, Associated Press, which owns that photo, tried to stop it for infringement. It was a big case. Finally, he admitted, yes, I did use that photo to create my photo. They were in court, but they settled in connection with it. So it protects original artistic expression. Because this wasn't all original, it was based on that work, he didn't have copyright rights in connection with it in that regard. And copyrights and trademark rights are not mutually exclusive. Mickey Mouse is a very, very famous trademark, and Mickey Mouse is a very, very famous copyright in that regard. So you can have one and the same in connection with it. It's just protecting different aspects of the same property. So copyright rights, whenever you're doing any of this stuff for your business, these are all copyrightable subject matter, all need to be looked at from a copyright point of view. And the next slide or so, we're going to talk about this. The one to keep in particular and concerned about is user-generated content. If you have user-generated content, you want to make sure on your website with any user-generated content, you have some contract and some language as to how you use that particular stuff. The other things you kind of have control over how it's being created and how it's being used. User-generated contract, what a lot of websites and companies use, is a little different game. So I won't go through all of this, but it's very important that you realize that the law presumes that the author or the artist is the copyright owner, absent circumstances of work made for hire. So in an employer-employee relationship, the employer always owns the work that the employee does in the regular course of their employment. If you have the receptionist go and take some photographs for you for the catalog, that may not be under the employer-employee relationship because that's not in her normal course of her employment in connection with that. But if you have your graphic designer that works for your company as an employee, design graphics for you, you own all those graphics.
So isn't one solution to get the employee to sign an agreement that anything that they invent or create on the job?
Yeah, that would be your preference, to have all your employees acknowledge when they hire. The difficulty in some of these rights is these rights don't accrue until they're created. So copyright rights are considered not to accrue until they're actually created. So copyright law requires that the assignment be in writing after the work and the rights exist in connection with that. So even in those employee cases, the best case would be to have someone sign it. The same with independent contractor. You say, well, I paid for it, so I own it, but that's not how the law presumes it. So in an independent contractor situation, you may have a contract with them that you'll pay them and they'll do certain works for you, but then you need to have a written document saying that they've transferred all the copyrights in connection with that. And there may be some trademarks, there may be some other things, so you would really like to have a general IP assignment.
So just so you know, we've handled dozens and dozens of lawsuits brought by our clients against software developers, graphic artists, what have you, because there was no contract or it was very unclear. There was nothing stated in the contract that they were developing the artwork or the software on a work-for-hire basis.
And you can imagine what happens is you contract with someone to do one thing, and they did it very well, and they're like, oh, well, you do this too, or do this too. And then your contract, which you had originally did have, doesn't cover all the other things that you did have them do. And so then you're in a difficult spot if you want to claim ownership if they decide not to continue on and acknowledge. Many businesses understand how it works, and many graphic design businesses and photographers will realize that if you paid for it, they did it for you, you do own it, and they'll sign those kind of rights. But not always. Registration, let's talk about this real quick. Register at the Copyright Office. Okay, everyone tells you copyright is automatic, and that's correct. Copyright is automatic under the law. Unfortunately, the US has a little twist on that unless you've registered it, you can't enforce it. So you've got the rights, but you can't go to court with them unless you have a registration. And there was what we call a split in the circuits of the circuit courts of the country until last year. The Supreme Court has determined that you must have a registration prior to bringing a copyright infringement action. And so that's a prerequisite to enforcing your copyright action, your copyright suit. The nice thing about copyright law that differs from other laws is that if you register your copyright prior to the infringement or within 3 months of publication, which is a very specific right, you can recover statutory damages, a set fee under the statute, under the law, and your attorney's fees. Collecting attorney's fees in the US is really not the norm. Usually the norm is each side pays its own way, win or lose. Not true in foreign countries, but this is these two things make copyright a very, very powerful tool and a very, very powerful asset for the company because of that. Online registration is through ECO, the e-Copyright Office, $35 for most applications. Very inexpensive to do, very easy to do. A very user-friendly system in connection with that. 4 to 6 weeks, have your registration. I don't do a lot of copyright registrations for the firm. I just train my clients how to do them because they can do them very efficiently and effective. There's like 8 or 9 pieces of information. They know all that. My job, if I'm doing it for them, is like, okay, what's this, what's this, what's this? And then I'm filling out the form and submitting it and charging them 10 times as much, unfortunately, to do it than they can do it their own. So copyright registrations are really easy to do yourself.
Just play back to me. You were saying a moment ago about an employee who works for you, if you had them sign a copyright
Employment agreement, typically, that includes that.
If they've created something that's really cool, you own it, but you haven't copyrighted it, you haven't registered it, so it's actually not valid. Is that what I heard?
No, the copyright's valid. It's just that and you can use it and you own it, whatever, but if someone else copies it and you want to enforce it, you want them to stop, unless they voluntarily stop, you can't go to court unless you've registered it. So you have to do that extra step. Domain name rights, I'm sure you're all familiar with what domain name rights are. And like I said, do this kind of before you decide on the trademark right, because if the domain name, if there's no domain name that's going to fit with that, then there may be a problem, and review the com, org, and net in connection with them. And again, take them if you are able to get them. Foreign countries, we recommend on clients that want to do their website in a foreign language that they do have the foreign domain, the corresponding foreign domain in connection with that. So if they're going to have a website in English in the U.S., but they're going to have a Japanese website or a website in Japanese, the .jp makes more sense to have and make sure that they have that reserved in connection with that. Common misspellings of your company name. And if your company name is misspelled, like you use a K when normally people would use a C, register the C as well on that domain in connection with it. Or you might want to even consider registering the K if your mark is with a C to prevent that copycat and lookalike thing. It used to be very much too that people would do negatives. They would do like American Airlines sucks, .com and things like that, whatever. And then it got kind of ridiculous because then people would do, so then American Airlines would get that back, and then someone would get American Airlines sucks big time, or really, really sucks, or sucks. And so then it got kind of ridiculous. But we still sometimes on certain clients, particularly where there's a lot of public facing, that they do lock up the negative in connection with their mark, in connection with that, again, inexpensive. These two things are very important too, because they're better than the trademark offices are of giving you reminders, but a lot of clients put something on auto renew and then kind of forget about it, and then forget that credit card changed numbers and is no longer going to be very good for the auto renew when it comes up, kind of do that. When domain names about 5 years ago, we were still being told that 20% of domains went back into that because of failure to renew, that people just had faulty records in connection with that. So it's very, very expensive to get a domain name back that you've lost inadvertently if someone else has then re-registered in that time period before you've noticed that, when the website goes down because of that change. Rights of publicity. This is a state law right that we talked about in connection with it. Some states are very protective. We're going to, I think, do another slide in connection with it. This is the commercial value of a person's identity or persona, most widely associated with sports stars, movie stars, recording stars, etc. But even individuals could have rights of publicity, a model that you may not otherwise know. If he or she's photo is used in connection with an unauthorized use of selling a product, they would still have some rights of publicity in connection with that there. So here, these are state rights. California has a very strong right of publicity. It's their life of the person plus 70 years. Same for Hawaii. Nevada is a little less. Tennessee's perpetual. They have a very famous person that they're trying to protect under the right of publicity law, so they have that. Indiana as well. James Dean was from Indiana, so Indiana has a very strong right of publicity law to protect that. Interestingly enough, New York, while most states have post-mortem rights, which means that those rights go on after death, they mean they're assignable or descendable to the heirs, New York has no post-mortem right. So anyone who was a New York resident at the time of her death, her rights of publicity expired at her death. She still may have some trademark rights through the estate or other things, but the rights of publicity expire. So this is a very important kind of thing to keep in mind. Many, many companies think that they can post on Facebook or Instagram in connection with a celebrity or someone using their product or wearing their product or whatever. That's not the case. This is where this law comes into effect. Dwayne Reed, which is kind of like a 7-Eleven or a convenience store kind of thing on the East Coast. Someone spotted Katherine Hagel during the heyday of her career there, walking out of the store with the bags, and so they posted this and kind of used this as publicity and marketing for their own store. After she asked them 3 times to remove it, and they did not, she sued them. So if your business inadvertently does something where someone in your business posts something on Facebook or Instagram with a celebrity and you get a takedown notice or request to remove it because it's a celebrity or personality, sports star, whatever, take it down. You can work it out and put it back up, but this is a very strong right in most jurisdictions. This was another interesting one. This was from Casablanca, which you may know. There's a copyright in connection with that movie. Burberry, he's wearing an actual Burberry trench coat in the movie. So Burberry on Facebook posted a lot of famous actors, people wearing actually Burberry products. They got permission from the movie studio to use this photo. They didn't have permission from Bogart's children. And so they sued, claiming that this was an infringement of the rights of publicity that they owned.
On the previous slide, what if instead of someone that famous, it was just kind of a local celebrity?
Wouldn't matter.
Same thing.
Yep. Now, it's up to them to decide what they're going to do with it. But typically, they're going to decide, especially if she has a contract with another entity, that she will be their spokesperson for that, and it's not Dwayne Reed, there's a lot of pressure for her to tell Dwayne Reed, take that down, kind of thing. It happens a lot with sports stars who are under contract with certain apparel goods or certain sporting goods, not to be wearing, other apparel or using other sporting goods. And sometimes they do, and sometimes they get photographed, and then, Adidas, Reebok, whoever, jumps on that, that's where it becomes really kind of a problem. But it's up to them. It's their right to decide. So if she's perfectly happy with this, which happens probably all the time, that's fine. But you won't necessarily know that, when you use it. That's why if you get a takedown notice, or request, take it down.
What about like a nobody like me? Like I'm wearing Nike and then they take a picture and they post it. What can I do?
So two things. I mean, if they're using it in a commercial sense, like they're using it to try to sell additional of that product, then there would be a right of publicity, even though you're not famous. But more likely it would be a privacy right.
Not yet.
But most likely it would also be a privacy right, that they're using your image in connection with promotion that you have not agreed to do in connection with it. So and this is an instance where they had some trouble in connection with that. So privacy rights. So the privacy rights go back a lot farther than a lot of us kind of think in connection with it. It was actually from Louis Brandeis, who wrote a Harvard Law Review about the right to be left alone. And that's really where privacy rights first started in connection with that. And that's wrong. That should be 1980. I mean, 1890.
1890.
Sorry, that must have been not caught.
Dyslexia.
So the other thing with privacy rights is they're becoming a bigger and bigger deal. It's becoming now a consumer right in connection with it. And so the General Data Protection Regulation, which went into effect a couple years ago in Europe, protects all Europeans in connection with privacy rights in an opt-out procedure. And then the California Consumer Privacy Act, or CCPA, that just went into effect a few weeks ago, does the same for California. This is a very, very strong consumer-forward, consumer-facing privacy act in connection. So as I'm sure you've seen, and whenever you're going to any website now, all these things pop up that you have to agree to in connection to go forward, and that's typically because they're trying to comply with that that consumer. So on this, Wendy has a little cheat sheet, we call it, if anyone's interested in connection with doing it, has a little bit of background information in connection with it. It's for-profit businesses, so nonprofits are exempt in connection with it. But it's on information of California consumers. And so if a business has revenue of 25 million or more, they qualify and they have to comply with this. If they have more than 50,000 California consumer data in connection with their holding, they have to comply with it. Or if 50% of their revenue is from consumer data that they buy or sell, then they have to comply with it. So it's just being enacted, but we do expect there is a consumer remedy, so we expect the consumer remedy in connection with it. There's also an attorney general remedy, which we think will not go forward really robustly for a while. We think the state will give businesses a time. But the consumer remedy, there are a lot of law firms who will take on any consumer who wants to sue a company because they don't comply with the CCPA. So there will be a business, just like slip and fall businesses and things like when potpourri and candles, everyone had to label their stores before you walk in if they had any kind of potpourri or scented material. There'll be a business of lawyers who will be suing businesses because they don't comply with that. So just be conscious of those. Nevada's doing a very strong one. I think eventually there will be a federal law, but who knows when that'll actually happen. But right now it's a state by state. And some states are really lenient. Other states like California are going to be very strict in connection with your opt-out. have to tell people what you collect, how you use it in connection with that, and give them the right to delete it or the right to inquire as to what you've collected about them. So that can be very onerous for businesses to comply with that. I think that's it. So I hope we did okay on time.